Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series designed to educate the public, so please subscribe to our channel. The question about disclosure of assets is a very interesting one because there's no question everybody's going to say if you're doing things the way you're supposed to during a divorce, you have a duty, you have a responsibility, even though it may hurt a little, to disclose all the marital assets so that the parties can litigate over the ownership of those assets and the division thereof. The question then becomes, what about if we're separated? We've been separated for a long time. We just never got divorced. Now finally someone's getting divorced. Am I obligated to disclose those assets that I acquired after that separation, but before that divorce? In other words, the in-between. Well, the short answer is yes. Because until you're divorced, you're still married. It's kind of binary in that way. You're either married or you're not married. If you're not divorced yet, so you were married, you continue to be married even though you don't live together. So once you leave the state of being single, you're either going to be married within the context of the marriage or you're going to be divorced in the context of the marriage. But it's going to be one or the other. So being separated isn't overly meaningful in terms of the fact that you, while separated, are still married. And because you're still married, you have a duty to disclose your assets. Now, having said that, if you've been separated for a long time, she's moved on, you moved on, she bought a house, you bought a house, are you going to be held to share your property because it's marital, even though you've been separated, even though you moved on, even though you have separate lives? Probably not. However, when you're in a situation like this, you don't want to be caught failing to disclose stuff. Both sides should disclose. More likely than not, the court's going to say, okay, this is what we accumulated during the marriage, that's marital. We're still married, but we're separated, so from this point on, we're going to pick a point after the separation when we had nothing to do with each other, and everything from that point forward, we're going to consider that separate property. It would probably be equitable for the court to engage in that analysis, and it probably will, all things being equal. But if you don't disclose it, then you run the risk that the court will think, God, what else are you hiding? You lack the credibility because the court will ask, have you disclosed all your assets? And if you're thinking, well, not really, but I'm not going to tell you because we had separated in June and I didn't get that till September, that's a tactical mistake. Because if the court were to find out, the court could say, you know what, we're going to include all of that or a portion of that as an asset to be divided when, if you would have disclosed it, the court might have said, you know what, we're not dividing it anyway because it's all done. So the better practice is disclose it, disclose when you got it so that it'll be clear to everybody and the attorneys can agree amongst themselves, okay, this is the cutoff we're providing to the court. We're going to propose to the court that anything acquired after this time, that should be separate property. It makes a lot of sense to do it that way. Now, if you have any questions about your case, reach out and we'll be glad to help you out.